SJC-11005, Commonwealth versus John Burgos.
Good morning. May it please the court. I'm Janet Pumphrey for John Burgos.
Wait, you need to start the clock. All right, now you're Janet Pumphrey.
Now I'm Janet Pumphrey for John Burgos. Your last argument for the month, right? I'd like to concentrate my remarks this morning on the first issue. I think it's dispositive of the entire case. The murder was not in connection with organized crime. The motion judge even conceded in her memorandum that the information in the affidavit is, quote, not as clear as to whether Haywood's murder was in connection with organized crime. She relied on, the judge relied on four findings for her ultimate finding that it was in connection with organized crime. First, that the defendant and victim were members of rival gangs. That's not the Commonwealth's burden to prove gang-related. The burden is to prove a nexus between the murder and organized crime, and I would suggest that's just not proven here. If gang affiliation was all that was required for a wiretap warrant, a wiretap would be authorized for all kinds of, probably all murders, or almost all murders in New Bedford, Boston, or Brockton. It's just not dispositive. Second, the judge's finding that two gangs were involved in multiple shootings is really not relevant. Murders and shootings, even with accomplices working together, are not organized crime.
Well, the organized crime, I'm not suggesting, I mean, I before we get to the connection of the murder to it, but the organized crime, right, is the being involved in drugs and guns.
That's right.
Each of the gangs.
That's right.
The affidavit.
Well, that is part of the argument, but the murder itself has to be related.
I understand that, but
So that's all connected.
yes. But I mean, I thought you were questioning even whether gangs.
No, if a gang is a drug distribution enterprise, it's organized crime. Third, the fact that the shootings occurred in the defendant's home territories is completely irrelevant. And fourth, the fact that the murder involved, and she found at least two accomplices and a waiting getaway vehicle, and that's just not dispositive, because even cooperation among cohorts is not sufficient. The crucial missing element in the judge's subsidiary findings is that nexus between the evidence of the murder and connection of the murder with organized crime. In my reply brief, I really parsed the facts of four cases, and there may be other ones, but I think these are probably the four primary ones in this area. And it's interesting because two fall for the Commonwealth and two fall for the defendant. And I would urge the court to look at those very closely. In Hearns, one of the Commonwealth's cases, the affidavit was very detailed, it was very specific. The gang's activities were organized. That's crucial. Senior gang members directed the drug selling and violence of the junior gang members. That was a chain of command. The gang used mission assignments to carry out its criminal objectives. In contrast here, there was no evidence at all of any highly organized working together, no evidence of chain of command, no evidence to mission assignments. Also in Hearns, the gang's activities, they were described as a distribution of drugs and weapons. In contrast here, what the affidavit said was, members of each gang are known to deal in narcotics. That's just not enough. There's no statement that the gang's business was this. The members of the gang dealt in narcotics, but there was not an organization to it. The motive in Hearns, the shooting was intended as an act of retaliation, intimidation, and the shooting was related to its illegal enterprises. And that's crucial. I mean, here there's just no such relationship between the shooting and the drugs.
There is the statement in the affidavit that I forget the name of the trooper
Spencer.
who said the affiant, not the affiant, it's.
Almeida. Rico Almeida? No.
No, the trooper, it's a trooper.
Oh, it's Spencer?
Trooper Spencer,
Spencer.
State Police Detective Unit.
No, the one, it's a female trooper who says to him, there is suspicion that that the murder was in retribution for the killing of somebody else.
That's exactly right, that there was some kind of a retaliation, and that was definitely voiced, but that still doesn't relate to the drug distribution or the illegal enterprises. It's just a murder, it's a personal motive. Similarly, in Mitchell,
Is it of consequence? I mean, the Hearns affidavit, I think, was written after Tavares,
okay,
so it had the benefit of
Exactly.
Tavares. This is 2009,
okay.
which I think
Tavares was 2011, am I right?
Tavares was on my watch.
Yeah, I
so
know it was
I
your
didn't write
watch.
it. I didn't write it, but I was on the court, and
And you wrote the concurrence.
I don't think it was after. It was
9 or
after. It was
10,
after March
9 or
2009. So,
Okay.
does it matter? In terms of our evaluation of it, does it change our evaluation to recognize that the affiant did not have the benefit
Of
of our
Tavares.
reasoning in Tavares in terms of wording the affidavit?
I don't think it matters for your thought process. But I do think it matters in terms of the future of, I mean, it would seem to me that just a little bit more fact-finding and a little bit more specific affidavits, and these would be fine. But it's just not here. And I don't, there's an unfairness to that it just doesn't comply with the statute. And Mitchell is the same, and I forget the date of Mitchell.
2014.
2014, okay. Mitchell, the gang was described as a drug distribution enterprise. The defendant himself was a drug dealer. He was arrested with several other people and a guy named Jeffries for drugs. Jeffries was a drug dealer. The defendant was one of his associates. There was evidence of a setup just the week before. In contrast here, there was no explicit reference that the gang was a drug distribution enterprise. Just members sold drugs.
Can one make the inference from what's in the affidavit? Well, let me step back. I gather that there's a question of how many affidavits are to be considered,
Yeah, there are.
and is the record clear as to what was before Judge Kane, or not so clear?
My understanding is that, and the Commonwealth did file a supplemental appendix with the second affidavit. The second affidavit it's in some ways very identical to the first affidavit is in some ways very identical to the second one. The first one was not signed, it was not dated, but the notary signature, it appears to have been written 2 years earlier. And it doesn't talk about Amita, and it doesn't talk about Burgos. It was before the judge, but there's a footnote in the decision that says that basically the judge didn't consider it.
Which judge?
The motion
McGuire
judge,
or
the
or
suppression
Kane?
judge.
Right, but how about Judge Kane?
How about Judge Kane?
Oh, I don't know. I don't know. I was talking about the suppression memorandum itself. There was a footnote.
And I've read the Spencer affidavit. I've not read the others. Do the others provide
It's very close. It's very
more
close.
detail as to the nature of these two enterprises,
I
these
don't-
two
No,
gang
not
efforts?
in my opinion, no.
Isn't the other related to the other murder?
The other one was, it appears the other one was related to the other murder. It's not about Burgos at all.
No, it's going to be about this.
Okay.
Now, I expect that your sister will contend that it's a fair inference that when you have two gangs in the same town with different turf, both involved in drugs, shooting each other, that a retaliatory shooting is part of the business of protecting one's turf. Is that not a fair inference that to say that the shooting is designed to demonstrate that nobody is to mess with us, and if you do kill one of ours, we'll kill one of yours?
I don't think that there's any evidence at all of any kind of a turf war, at all. Again, there's certainly evidence, although the word gang was never used, there was certainly plenty of evidence that that's what was going on here. But there was no evidence of drugs either, other than just the passing reference that the gang members sold drugs.
Well, there wasn't that much in Hearns either, as I recall.
Okay.
But didn't you say there was a finding that the shootings took place on the defendant's territory?
That's right.
So isn't that what Justice Gantz means by turf?
Oh, that is what he means by turf, but I'm just saying that doesn't necessarily relate to the drug dealing. It just relates to the fact that this was these are neighborhoods. There's the United Front and there's Monty's Park, and they do have, the members of the gangs are in those neighborhoods, and that's right.
Okay.
It's just that it doesn't relate to
To drug dealing.
to organized crime.
Exactly right, not to organized crime at all. The motive in Mitchell was a business interest, economic threat to the defendant's gang's economic interest. Here, there was no economic threat at all. This was just it was a personal motive, it was retaliation. And the cases that fall on the defendant's side are very much like this case, Long and Tavares. In Long, as here, there's no basis for inferring that the murder was a continuing criminal enterprise to supply illegal goods or services. Not here. In Long, as here, the discipline, organization, and continuing nature were just not present. As here, this is only any kind of conspiratorial efforts amount only to a coordination among cohorts. It's not organized at all. And in Long, as here, the motive was retaliation. That's the motive here, and I would suggest that that's a personal motive. Similarly, in Tavares, there's no co-defendant in this case.
Well, Tavares, I mean, the retaliation seemed to be a personal, it wasn't, well, that's, at least if you take Trooper Robertson's statement.
In Tavares?
Here.
Here, okay.
It's more that the gang organization is retaliating against the other gang organization. It isn't
Even if-
some member who's, at least in Tavares, is sort of a rogue.
Right, right. Well, even if that's the case, I would still say that it's still not necessarily a criminal enterprise. It's not an organization. We don't know that there was an authority, some directive from someone else to do this. It seemed random. It seemed like two people working together. In Tavares, there was.
Are we basically talking about search warrants that have enough information in them, but
That's right.
are perhaps not well-written, not well organized?
Certainly could be, they needs to touch all these bases. I mean, the wiretap search warrant is, the statute is very specific, and all the bases need to be touched, because it's a highly intrusive violation of violation of privacy. Also in Tavares, as in here, the defendant himself wasn't involved in drugs. There was no evidence at all that the defendant had anything to do with a drug, criminal, or contraband trafficking. There was no evidence that this was connected to a commercial trade, no evidence of discipline, organization. And so basically, in conclusion, the primary element here, because if a wiretap can be this easily obtained, it'll be obtained in every single murder in the Commonwealth. It's not the intent of the wiretap statute, it's not the language of the wiretap statute, and the legislature has yet to take up, Judge Gantz, your suggestion that they change the wiretap statute, because all they have to do is take out the language in connection with organized crime, and this useful investigation tool could be used with all kinds of cases like this one. The wiretap statute requires, first, the showing that the application was in conformity with the section. It has to be in furtherance of a criminal enterprise. Secondly, that there is probable cause. And third, that other procedures either have not been tried or have been tried and failed. The Commonwealth argues that there's no expectation of privacy in a conversation that occurs in a jail cell, and that's certainly true in a normal sense.
Which one of the sections of the statute was the warrant issued under? Was this a one-party consent warrant?
It was a one-party
Or
consent.
was it the other type that would require probable cause?
I think it requires probable cause. It was certainly filed under 99, Section 99.
Okay,
I
well,
would suggest that it requires probable cause, and probable cause was discussed by the motion
well,
judge.
what about the case, and I'm not remembering the name of the case now, citing Thorpe, that the standard is reasonable suspicion for the one-party consent warrant.
Well, I would say that Thorpe doesn't apply. Thorpe was very different to this case. In Thorpe, the person who was actually doing the recording was a police officer. He was known by the defendant to be a police officer, but more importantly, it was a warrantless search and under exigent circumstances. So I think Thorpe is very different, as is the Rodriguez case also.
Well, are you suggesting a blood warrant was needed
I am,
for a jail cell?
I am.
If that's his home?
Well, no, because I think that even though there is no reasonable expectation of privacy in a jail cell, if you took that to a different context and wired an informant, and the informant was to record conversations, say on a public street in front of the police station,
Yeah.
there's no reasonable expectation of privacy there, but you wouldn't say that that was,
Well, I wouldn't say you need a blood warrant.
well, I would say that you do. I would say that you do.
It has to do with one's home.
It's not, I would say that you need one.
But why?
Why? Because it's so incredibly intrusive, and I think the statute applies here.
So what about this makes it so intrusive if it's not in the home? I mean, that was the problem.
Well, I think that it should not be difficult to get this kind of a warrant if the police officer just touches all the bases, in my opinion. If there's probable cause, I believe there should be probable cause. The warrant is certainly obtainable if the affidavit is written correctly and if there's probable cause.
But how does that help you, since the affidavit says Mr. Almeida, who I identify by name, said he spoke to Mr. Burgos. Mr. Burgos told him how, that he did the killing and told him how.
Well, I would say
Is that not
two-
probable cause?
Well, two things. One is, it's a hearsay letter from Almeida to begin with. He says that Burgos told him why, where, and when they killed Haywood. And although this isn't relevant to this inquiry, that turns out at trial to be completely untrue, because as Almeida was,
Yeah, but that's not,
it's not relevant here.
it's
But,
probable cause at the time.
At the time, it seemed to be. And I would just say that this is not, this just falls short of the reliable information that's needed to show probable cause. The veracity of the informant, Almeida's veracity was nil.
But he's named.
He's
I mean,
named. He is
This is
named.
not a confidential informant. This is a
Is
named informant.
He is named, he's named. But I would suggest that both of those bases needed to be touched, the probable cause and certainly the connection to organized crime.
Okay, if I can turn you to your reply brief with regard to the corroboration requirement.
Yes.
Let's assume we say you're right, that you need more than corpus delicti. How does it help you? I mean, isn't there corroboration here with the hat and with the grandfather of,
Shell casing.
and with basically them being together? I mean, there are corroborating facts here to the defendant's involvement in the killing, is there not?
There's not much. There's
Well,
not.
how much do you say you would need?
Well, you need
is it some corroboration, or is it more than that?
I think it has to be more than that. I think it has to be significant, I would say significant corroboration. I mean, here, if you turn to the DA's closing, in the DA's closing, he basically mentions four things that were particularly evidence of other evidence of guilt. One is the laughing, one is the toasting, and I would say that's not evidence at all, because this is the 4th of July. They're at the city's fireworks, and they're laughing and toasting, and afterwards they're drinking beer, and that's not evidence at all of guilt. And the blue baseball cap. There's a blue baseball cap found at the scene. There's more than one person's DNA found on the baseball cap. The defendant's DNA is there, but it's pretty clear that it didn't necessarily have to be left that night. It could have been left at any time. And also, the Commonwealth's entire theory was that the two perpetrators were wearing do-rags. There's no testimony at all of a blue baseball cap, other than there was one found at the scene. And the shell casings in Payne's car are probably the most interesting, because Payne and Burgos were definitely together that night. The police investigation of Payne was almost non-existent at the time, and then now Payne is deceased because he was also killed. But they find about 2 months later a shell casing in his grandfather's car. But they didn't go and arrest Payne at that time. They didn't even investigate Payne. So I don't really think a shell casing 2 months later in Payne's grandfather's car is evidence of Burgos' guilt.
Now, the judge dismissed the firearms count. Is that
Yes.
because the thought was that Payne may have been the shooter?
I think that was the thought. I think, and then that really does make sense when you think about it, was I don't know. So I would suggest that I gave you all the reasons for modifying the corpus delicti rule, and I won't go through all of them here, but I think that just the fact that the Supreme Court and almost all the federal courts in many, many states have adopted another standard, that is the trustworthiness of the confession, which is a much more important focus for the court than it is on whether the crime actually existed or not.
All right, thank you.
So, thank you.
May it please the court, Tara Blackman for the Commonwealth. First, I want to start off by clarifying something. My sister skips around. She argues that first, the requirements for under the wiretap statute for a wiretap warrant weren't satisfied. She also argues for a blood warrant. The fact of the matter is that in this case, no warrant was in fact required. One, because this was under the one-party consent exception to the wiretap statute. And two, a blood warrant was not necessary because the conversation happened in a jailhouse, and a blood warrant is limited, as this court has recognized, to privacy of one's home. In fact, in Hearns, this court said that it did not even extend to the privacy of a defendant's vehicle. It certainly does not extend to a jail cell where a third inmate can be overheard interrupting the conversation and the defendant being aware of that in an adjacent jail cell. Therefore, no warrant was in fact required in this case. Perhaps out of an abundance of caution, the police did obtain a warrant in this case. However, the question under the one-party consent exception to the wiretap statute is the information that the police had at the time of the recording. Now, of course, there are two requirements to that. One is undisputed, that the recording was done with the one party's consent. Undisputed here that the recording was done with Almeida's consent. So really the only issue we have is, was this a designated offense committed in connection with organized crime? And I believe that question is answered by the definition of organized crime in the preamble of General Law 272, Section 99, and by this court's recent decisions in Hearns and Mitchell. In the preamble of 272, Section 99, as this court knows, organized crime is described as highly organized and disciplined groups engaging in the supply of illegal goods and services, and in doing so, committing violent and brutal unlawful acts. And for Hearns and Mitchell, this court recognized that that can take place between this type of organized crime. It does exist, or reasonable inference that it exists, when two rival gangs are engaging in the illegal sale of narcotics, possession of firearms, and shootings. This court
A
recognized—
lot less than was in Hearns, you have to agree.
I agree that there's less than there was in Hearns, yes, Your Honor, in terms of the organizational structure. But however—
And also the connection of the killing to the, quote, organized crime.
I would say that there's less than Hearns. There's about the same as there was in Mitchell, though. So I would say, yes, there was less than there was in Hearns. However, as Justice Gans just pointed out, the fact of the matter is what we know is what's set forth in the affidavit. In Hearns, the court did have the benefit of the court's decision in Tavares. Here, the affidavit was written before that. Regardless, though, I would say that this case closely mirrors the facts of Mitchell's in terms of the connection, that there was a reasonable suspicion. And again, we're looking at whether there was a reasonable suspicion that the shooting, the designated offense, in this case the murder of Haywood, was done in connection with organized crime. And the facts we have here, we have ample facts set out in Trooper Spencer's affidavit. Those facts are that two rival gangs We know it was a continuing nature because we know from the affidavit that the defendant, Burgos, was a 12-year member of the United Front. We also know that Haywood was a member of the Monty Park gang. We know these were two rival gangs. We know that it was believed by the police, that the murder of Haywood was done in retaliation for
Well,
the...
all it says is it was suspected. We don't have any reasonable basis for the suspicion that's articulated here. Do we?
What it says, from what we know in the affidavit, that it was believed that the police, that it was done in retaliation for the murder of...
But that's just a statement. I mean, it doesn't have any rationale.
Right, well, that's what's set forth in the affidavit,
Reading the affidavit.
Right, no, I know, and that's what we have to go on in this case. That's what we're using. Of course, an affidavit wasn't required in this case, otherwise, but it was based on the information that the police had at the time, but yes. But the thing is that that was one of the pieces of the puzzle that the police went on to go on, that this was done in connection with organized crime. It's just one of the pieces that the police had. The police also knew that at the time that Burgos and one of his other fellow gang members, John Barry, had been shot at in 2006. John Barry was actually murdered in that. And somebody from the Monty Park gang was the suspected assailant in that.
But what's the criminal enterprise underlying the shootings that are going on between the two groups? That's the problem. I mean, I don't think that there's any doubt that there's shooting and retaliation, but you need more than that. You need a criminal enterprise driving that conduct. So what is the criminal enterprise?
Of course, Your Honor. Well, what I would say to that is that in the criminal enterprise in Mitchell and in Hearns...
No, in this case, what is it? What is it?
Well, so a drug enterprise. And I would say that the reasonable inference is...
Where's the evidence of that?
Well, it says that both gangs were heavily involved in the distribution of narcotics, the possession of firearms, and multiple shootings. I would say that a reasonable inference can be drawn from that in fact this was a drug enterprise, a highly involved. There's not much to distinguish saying a gang is highly involved in the illegal distribution of narcotics and the possession of firearms, and saying that this was a drug enterprise. That is basically what a reasonable inference, that's what it amounts to. So, and that is, in fact, that in this court recognized in Mitchell, that in fact it doesn't need to be solely, the shootings don't need to be done solely for a pecuniary interest. And there can be some type of underlying personal issue there.
Can you refer me to the part of the affidavit that says that there was a drug enterprise going on? Where does it say
Well, in
that?
our case, we have the illegal sale, heavily involved in the illegal sale of narcotics.
Who said that?
This was in Trooper Spencer's affidavit.
Okay. And this affidavit was the one that was submitted in connection with a totally unrelated case.
No, actually, the Trooper Spencer's affidavit was submitted in connection with this case.
I take that back. What happened was Spencer's affidavit was submitted in connection with this case, but everything he says is what he knows from a prior affidavit that was submitted by another police officer involved in another investigation, right?
Well, some of what he knows. So some of what's included in Trooper Spencer's affidavit was from Trooper Dockery's affidavit, and that was regards to the other case. That was
And
regards to...
so was Trooper Dockery the one who came up with the revelation about the drug enterprise, or was that something that Trooper Spencer came to on his own?
I believe that it was collective, but I believe that it was understood by all that they were involved in the illegal distribution of narcotics. I think that we have several officers in that affidavit being referred to.
Well, how is that reliable if he's talking about something that was 2 years prior? Don't you need something more recent than what Trooper Dockery knew 2 years ago?
Well, there's also the information from Trooper Anne Marie Robinson. There's also what Trooper Spencer knew about these gangs. These gangs are, and I think this is something this court looks to, is whether or not it's organized crime, is whether or not this is of continuing nature. This was a continuing rivalry between the United Front gang and the Monty Park gang. These were long-standing members, and this
A
is
rivalry, yeah, but what about continuing criminal enterprise? I mean, you've got a 2-year gap there. What are you filling the 2-year gap with?
Well, I don't believe that it's just from Trooper Dockery. It's partly from Trooper Dockery from his affidavit. What mainly is in Trooper Dockery's affidavit is about the rivalry and the multiple shootings between the gangs. So I think that the part about the illegal distribution of narcotics, that is just, that's something actually I think
That's
from
actually coming, at least according to this, from the New
Troopers-
Bedford Police, from
Detective
Detective Lieutenant
I
Sylvia.
believe.
Yeah.
Yes. So I don't think that there's anything saying that that was from just 2 years before. I think that that is current, and that Trooper Spencer is relying on current information, not just about the rivalry between the two gangs, but both of these gangs' involvement in the illegal distribution of narcotics. As this court recognized in Mitchell, it doesn't need to be solely about about the group's pecuniary interest, and there can be something underlying it with respect to perhaps a personal vendetta, which I don't believe there was any evidence of in this case, and that was really what it was about in Tavares and Long. So it's very distinguishable from this. Those cases are extremely distinguishable from this case, where those were just rogue acts of individuals acting on their own, and then they involve their cohorts later to maybe cover up what they did. This is much more similar to the facts of Hearns and especially Mitchell. But I think the important point is to look at is again, is the information that the police had about this long-standing rivalry between the two gangs. Look at the illegal sale of narcotics, and look at what this court said in Mitchell in terms of the gang's interest in protecting their territorial interests, their reputation, and there are many reasons why, in furtherance of their illegal enterprise, and that they commit these acts of violence. And part of it is to protect their customer base, part of it is to protect their reputation, part of it is to intimidate other gangs. So there are many reasons why these shootings are taking place, but they all lead back to the fact that this is in protection of their organized criminal enterprise.
Now, of course, that's not, if we read that, we have to read between the lines to get that, because the lines don't say that.
Well, I think that it's based on reasonable inferences, Your Honor. I think that all of those are reasonable inferences from the affidavit, and as I said, I don't think that this case is much different than Mitchell. In Mitchell, it was pretty much almost the same, except that in Mitchell, I think what the words used were drug enterprise, and here we have heavily involved in illegal distribution of narcotics and possession of firearms and multiple shootings, and I don't think that there's much to distinguish between the two.
But in terms of the connection between the murder and the organized crime, there really is a single sentence, which is that Trooper Robertson informs me that investigators believe that Hayward's murder is suspected to be in retaliation for the fatal shooting of Lopes. I mean, that's the only motivation given for the shooting.
Well, I think the motivation is also the fact that the longstanding rivalry. Yes, that is the motivation for that particular shooting, but it's not about a personal. It's about getting back at the gang for that shooting in general, and that's something that we know as is developed at trial. But of course, that can't be considered in whether or not the recording was proper, because we look at what was the evidence the police had at that time. But this certainly seems to be a retaliatory act not about a personal vendetta, even on the basis of what's in the affidavit, but rather on the basis of gang affiliation and about protecting those gangs' criminal enterprise, and specifically the illegal distribution of narcotics in this case. My sister also raises a claim about that these statements should have been, the trial counsel was ineffective for not moving to suppress these statements based on not raising a Fifth Amendment claim. Of course, as this court well knows, because the defendant wasn't subject to custodial interrogation when these statements were made, and there was no issue of coercion or voluntariness, there is no merit to that claim. My sister, of course, also raises that the motion for required findings should have been allowed, and she discusses the corpus delicti rule. Regardless, it doesn't matter because every piece of the defendant's confession, and I also note in this case, it was not just the recording of the defendant's confession that came in. It was also Almeida's testimony saying what the defendant told him and discussing the confession. Each piece of that confession was corroborated by other evidence in this case. So regardless of the corpus delicti rule or what this court would decide in terms of altering that, what have you, it's irrelevant because in this case, each piece of the defendant's confession was corroborated by other evidence. Evidence about the guns, evidence about who the defendant was with when he committed the murder, evidence about what he was wearing when he committed the murder, evidence about him going to the mother of Haywood's children after the murder, to her house, and seeing pictures of the defendant on the wall. There can't possibly be any more corroboration of a defendant's confession than there was in this case. In addition, of course, we have the recordings, the telephone recordings that were admitted of the defendant talking to his brother over the jailhouse phone, discussing that he wanted to, in fact, or suggesting that he wanted to avenge for the killing of his fellow United Front gang member, Cecil Lopes.
What if the jailhouse confession is out of the case? What is left for the Commonwealth?
Well, what's left for the Commonwealth, I would say, is still a lot. It's still substantial because we still have the defendant's confession coming in, just not through the recording. We still have it coming in through Almeida's testimony. And now, of course, the Commonwealth recognizes Almeida himself was not the most credible of witnesses in terms of his personal credibility. The Commonwealth, of course, recognizes that. However, his testimony itself, talking about the confession, that was credible. And that wasn't credible because of who Almeida himself was. That was credible because each piece of what he testified to about what the defendant told him was corroborated by other evidence. The guns that were used, what he was wearing, his actions after the murder, where, when, everything. And therefore, even if Almeida wasn't the most credible of witnesses in terms of who he was, the fact of the matter is the confession itself and what came in through Almeida was in fact corroborated, and that was in fact credible. So I'd say the Commonwealth still has a lot. Now, of course, if this court were to look at whether or not reversal was required, if the court would, on the off chance that the court, or on the chance that the court would find that it didn't satisfy the one-party consent exception and the recording shouldn't have come in, which again, the Commonwealth strenuously feels that this is so close to Mitchell and that shouldn't be the case. However, if that were the case, of course, it would be to this court's discretion whether or not this court found prejudicial error in terms of whether it mounted to prejudicial error, that recording coming in. But the Commonwealth still did have substantial evidence at trial.
Well, if the defendant isn't heard saying on the tape what Almeida says, Almeida's testimony probably wouldn't amount to much, would it?
I would normally agree with Your Honor because Almeida was, again, as a witness, was not the most credible of people. However, his testimony...
So doesn't that affect the level of prejudice to the defendant if otherwise the evidence against him is very much lacking in credibility?
Well, again, Almeida was not the most credible of witnesses as a person, but he became credible because everything he testified to in terms of his testimony regarding the defendant's confession, every piece of that was corroborated by other evidence at trial. So did the recording, of course, was the recording strong evidence for the Commonwealth? No doubt, yes. But however, there was other very strong evidence against the defendant. And was that partially the defendant's confession? Yes. And does Almeida's credibility come into play? To some extent, perhaps. But however, the fact of the matter is, everything was corroborated that Almeida said by other evidence. Of course, we also have the defendant's baseball cap with his DNA being found at the scene of the evidence. We have the telephone recordings where he's stating that he is finding out that someone from the Monty Park gang murdered his friend Cecil Lopes, and that he potentially wants to get revenge for that. And then we have the shell casings found in Payne's car a few months after following the murder, and we know the defendant was with Payne on the night of the murder. So almost every piece of that confession is corroborated by other evidence, and that does amount to very strong evidence for the Commonwealth.
Just one last question. Does the defendant's statement during the conversation with Almeida that he's very upset that this happened to his friend, does that detract from the organized crime rubric that you're trying to establish here? I mean, here you have this defendant practically in tears as he's talking to the witness, that concerned about what happened to his friend.
Right, well, again, but he's trying to generally retaliate, and also we don't look to the conversation in determining whether or not this satisfied the organized crime portion, but what we look to, in fact, was the information the police had at the time that they decided to make the recording.
If the rogue people, if that's not organized crime, why is this different?
Because we know the defendant didn't act alone. He acted with someone else at the time. There was also, the police in the affidavit, it's even stated that 3 people were there, 2 people doing the shooting, and then there was a getaway car. This was not some rogue random act. This was a planned thing could be inferred by several members of the same gang, but regardless, we know that there was more than one person involved, and it certainly does appear to be premeditated, and that's one of the reasons, because this was such a cold-blooded, premeditated execution type killing, that this wouldn't be also, last point, an occasion for this court to exercise its 33E review to reduce the verdict.
Great.
Thank you.
Thank you.